to continue, let's go now to the doctrines concerning culpable crimes. First is the emergency rule. A person who is confronted with a sudden emergency may be left no time for thought, so he must make a speedy decision based largely upon the impulse or instinct. Okay? So this is the concept of the state of necessity. So, importance cannot be held to the same conduct as one who has had an opportunity to reflect, even though it later appears that he made the wrong decision. Okay? So, the state of necessity or the emergency rule can be a valid defense, okay, for culpable crimes or felonies. Next is the doctrine of last clear chance. This doctrine contemplates that the contributory negligence of the party injured will not defeat the action if it be shown that the accused might, by the exercise of reasonable care and prudence, have avoided the consequences of the negligence of the injured party. Okay? So, under the law, the last clear chance doctrine is applicable mostly on vehicular accidents. Okay? So, if upon prosecution, it is proven that the accused has the last clear chance, okay, to avoid the injury, then the accused can be held liable. Okay? So, these doctrines are applicable in cases involving culpable crimes or felony. But, the doctrine is not applicable in criminal cases or intentional felonies. Okay? So, jurisprudence will be discussed later. Next is the rule of negative ingredient. This is related to the doctrine of proximate cause and applicable when certain causes leading to the result are not identifiable. Okay? So, this rule states that the prosecution must first identify what the accused failed to do. And then, once this is done, the burden of evidence shifts to the accused. And then, the accused must show that the failure did not set in motion the chain of events leading to the injury. Okay? So, the job of the prosecution is to identify the fault of the accused, and then the burden of proof will shift, okay, against the accused. So, next topic is impossible crimes. So, we will just make a rundown considering that this is just an overview of the criminal law system of the Philippines. So, impossible crimes. Purpose of punishing impossible crimes: to suppress criminal propensity or criminal tendencies. Objectively, the offender has not committed a felony, but subjectively, he is a criminal. Okay? So, the term itself, impossible crime, it is a misnomer. Okay? Because it is a crime committed, but it was coined impossible. Okay? So, is there such a thing? Of course, there is. It will happen if the following requisites will concur. First, that the act performed would be an offense against persons or property. Okay? So, the acts involved should be violations against a person or its property. Next, that the act was done with evil intent. Okay? Considering that intent is an element of intentional felony or felony involving dolo or malice. Okay? So, the offender intends to commit a felony against persons or against property, and the act performed would have been an offense against persons or property. Next, it must be shown that the actor performed the act with intent to do an injury to another. Next, however, it should not be actually performed, for otherwise, he would be liable for that felony. Okay? So, third, that its accomplishment is inherently impossible, or that the means employed is either adequate or ineffectual. Okay? So, the prosecution must take note of the means employed by the perpetrator, because if it's inadequate or ineffectual, or its accomplishment is inherently impossible, then the perpetrator can be charged of an impossible crime. Okay? So, what does inherent impossibility means? The act intended by the offender is by its nature one of the impossible accomplishment. So there must be either first, legal impossibility, or second, physical impossibility of accomplishing the intended act. So what does legal impossibility means? So the intended acts, even if completed, would not amount to a crime. Okay? So legal impossibility would apply to those circumstances where, first, the motive, desire, and expectation is to perform an act in violation of the law. Next, there is intention to perform the physical act. Next, there is a performance of the intended physical act. And then lastly, the consequence resulting from the intended act does not amount to a crime. Okay? So, another element is physical or factual impossibility. Okay? So, extraneous circumstances unknown to the actor or beyond his control prevent the consummation of the intended crime. So, in the Philippines, impossibility of accomplishing the criminal intent is not merely a defense but an act penalized by itself. Okay? So, that the act performed should not constitute a violation of another provision of the revised penal code. Okay? So that you can understand it clearly, we have an illustration. The victim was tortured to death. He was later shot in the back to make it appear that he was killed while trying to escape. The accused is not a principal to an impossible crime, but an accessory to the killing committed by the principal. Okay? So, since the offender in an impossible crime has already performed the acts for the execution of the same, there could be no attempted impossible crime. Therefore, there is no frustrated impossible crime, either because the acts performed by the offender are considered as constituting a consummated offense. Okay? So, I will give an example. Okay? On example in a case of an impossible crime. For example, there is a person who committed rape to a corpse, okay? So you cannot file a rape case because that person, the victim is already dead, okay? So it is an impossible crime to commit rape on a dead person. So instead of filing a rape case, then the prosecution can file an impossible crime. Okay? So next, felonies against persons under the revised penal code are the following: parricide, murder, homicide, infanticide, abortion, duel, physical injuries, and rape. Okay? So these are felonies which are found in the revised penal code. Next, felonies against property. Okay? Robbery, brigandage, theft, usurpation, culpable insolvency, swindling, and other deceits, violation of chattel mortgage, arson, and other crimes involving destruction. Okay? Malicious mischief. So, these are cases or felonies which are committed against property and also found inside the provision of the revised penal code. So, we have discussed the concept of impossible crime. Okay. Now, let's go to the stages of execution. Okay. So, classification under Article 6. Like what I have discussed earlier, okay, there are stages in executing a felony. So, these are consummated stage, frustrated stage, and attempted stage. So, by consummated, it means all the elements necessary for its execution and accomplishment are present. Okay? So, the felony is produced. Okay? The felony has been executed. Okay? Fully. Next stage is the frustrated stage. So, when the offender performs all the acts of execution which would have produced the felony as a consequence, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. Okay, so classic example, frustrated homicide. Okay, so you plan to kill a person. However, when the person was brought to the hospital, he was saved by the doctor. So, instead of filing a case of homicide or murder, you file a case for frustrated homicide because the acts were done to kill the person, but there are independent causes or intervention, okay, which is independent of the will of the perpetrator, that due to that intervention, the crime, the result was not the crime intended. Okay? Next is the attempted stage. So, when the offender commences the commission of a felony directly by overt acts and does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. Okay? So, the element of attempted felony is there are causes or incidents other than spontaneous desistance of the perpetrator. Okay? So, it is very important to differentiate these stages, class, so that the prosecutor can successfully prosecute the perpetrator. Okay? So, you have discussed this. What is an overt act? It is a commission of the felony is deemed commenced when the following are present. So, when you say overt act, these are external acts. Okay? Such external acts have a direct connection with the crime intended to be committed. Okay? So, when you say overt act, there is performance. Okay? There is action on the part of the violator or perpetrator. Okay? So, some physical activity or deed, but not necessarily physical, depending on the nature of the felony. So, like what I have discussed earlier, there are commissions and there are also omissions. Okay? Non-performance, so you can still be held liable, indicating the intention to commit a particular crime more than a mere planning or preparation, which, if carried to its complete termination following its natural course without being frustrated by external obstacle nor by voluntary desistance of the perpetrator will logically and necessarily ripen into a concrete offense. Okay? Overt acts are the actions, the performance, the external acts. Okay? So, these are the development of a crime. There are internal acts. There are external acts. Okay? There are preparatory acts. Okay? Then, acts of execution. Okay? You can appreciate these definitions when you read the cases that I will give. Okay? So, during the attempted stage, the elements are the following. The offender commences the commission of the felony directly by overt acts. Second, he does not perform all the acts of execution which should produce the felony. Lastly, the non-performance of all acts of execution was due to cause or accident other than his own spontaneous desistance. Okay? So, bear in mind, class, in different stages, there are different results. Okay? So, you just examine the result in order to know the stage. Okay? Whether it's attempted, frustrated, or consummated. Okay? So, when you say consummated, all acts necessary are done and then it resulted to the crime. So, when you say attempted, all acts were not carried out, okay? Or some acts are carried out, but the result does not, the result was different other than what is intended. So when you say frustrated, you have carried out all the acts, but the result was different than what is intended, okay? So, now let's go to the frustrated stage. The following elements must concur in order for the acts to be considered as a frustrated stage. First, the offender performs all the acts of execution. Okay, there is performance. There is overt acts. Next, all the acts performed would produce the felony as a consequence. Third, but the felony is not produced. Okay, the perpetrator performed all acts necessary. However, the result was not produced by reason of causes independent of the will of the perpetrator. Okay? Now, what are crimes which does not admit of frustrated stage? Okay? So, the following crimes has no frustrated stage. It's either consummated or attempted. Okay? One is the crime of rape. Next, the crime of arson. Next, bribery and corruption of public officers, adultery, physical injuries, okay, theft. The rule of thumb, felonies that do not require any result do not have frustrated stage, okay? So, what are the factors in determining the stages of execution of a felony? Okay? So, as a police officer or as the prosecutor, you must take note of the manner, okay, of committing the crime. And then you should also bear in mind the elements of the crime and the nature of the crime itself. So, these three factors are helpful in trying to pinpoint whether the crime is still in its attempted, frustrated, or consummated stage. So, the manner of committing the crime are the following. There is formal crimes. There is crimes consummated by mere attempt or proposal by overt acts. There are felonies by omission. Okay, by the way, class, I have uploaded the notes in the files. So, while watching this video presentation, please open the notes for reference purposes, okay? Next, because our discussion is just an overview of the topics Criminal Law 1. Next, crimes requiring intervention of two persons to commit them are consummated by mere agreements. And then material crimes have 3 stages of execution, okay? These are just matters of reading, class. So elements of the crime, we have discussed it earlier. Now, let's go to conspiracy and proposal. So, what does conspiracy mean? So, conspiracy exists when 2 or more persons come to an agreement concerning the commission of a felony and decide to commit it. Okay? So, what are the elements of conspiracy? So, when there is conspiracy, 2 or more persons come to an agreement. Okay? Agreement presupposes meeting of minds of 2 or more persons. Next is the agreement pertains to a commission of a felony. Okay? Agreement to effect what has been conceived and determined, and then the execution of felony was decided upon. Okay? So, take note, there must be participation in the criminal resolution, because simple knowledge thereof by a person may only make him liable as an accomplice. Okay? So, in conspiracy, the act of one is the act of all. That is why participation in criminal resolution is important. Okay? Because mere knowledge of such criminal plan, the person who just learned the plan can be held liable not as a conspirator but only as an accomplice. Okay? So, general rule, conspiracy and proposal to commit a felony are not punishable. Okay? Exception, they are punishable only in the cases in which the law specifically provides a penalty thereof. Okay? So, what are these crimes? These are treason, rebellion, insurrection, okay? Crimes against national security, class. Okay, kudeta, sedition, monopolies and combination in the state of trade or espionage, illegal association, highway robbery, espionage, selected acts under the Dangerous Drugs Act, arson, terrorism. Okay? So those which are found under the revised penal code and other special laws which are mala in se in character, like provisions under the Dangerous Drugs Act, okay, and provisions under the anti-terrorism law. Then proposal to commit treason, kudeta, rebellion, and inducement not to answer summons, appear, or be sworn in Congress. Okay? So the rationale is conspiracy and proposal to commit a crime are only preparatory acts, and the law regards them as innocent or at least permissible except in rare and exceptional cases. Okay? So when there is no overt act, okay, there is no attempt to commit the crime, as the general rule, conspiracy and proposal to commit a crime are not cannot be prosecuted unless provided by law. Okay? So these are just matters of reading. Okay? Matter of reading. Matter of reading. Matter of reading. Okay, you can appreciate these concepts in the cases that I will give. Now, let's go to an important part of the revised penal code, which are the circumstances which affect the criminal liability of the perpetrator. So, we will just make a rundown, class, okay? So these are the justifying circumstances, exempting circumstances, mitigating circumstances, aggravating circumstances, alternative circumstances, and absolutory cause. Okay? So, we will discuss justifying circumstances. Okay? So, when you say justifying circumstances, those were where the act of a person is said to be in accordance with law, so that such person is deemed not to have transgressed the law and is free from both criminal and civil liability. So there is no civil liability except in paragraph 4 or article 11, where the civil liability is borne by the persons benefited by the act. Okay? So when you say justifying circumstances, even though your acts, okay, you have committed acts which can be prosecuted under the revised penal code. However, your acts are justified. Okay, for example, you are a police officer and you kill somebody in the performance of your function. So it is a justifying circumstance because it is your duty. You are duty bound to preserve peace and order in your community. Okay? So, let's discuss the concept of self-defense. So, includes not only the defense of the person or body of the one assaulted, but also that of his rights, the enjoyment of which is protected by law. Okay? So, the following self-defense is a valid defense when you are prosecuted. Okay? Because you can use it as a justifying circumstance, like the right to honor. Okay? And then defense of property rights can be invoked if there is an attack upon the property, although it is not coupled with an attack upon the person of the owner of the premises. Okay? So, in order to use self-defense as a defense in the prosecution, okay, you use it as a valid defense against the prosecutor. So, elements of self-defense must concur. Okay? There must be unlawful aggression. Next, there must be reasonable necessity of means employed to prevent or repel the aggression. And then last, there must be lack of sufficient provocation on part of the defender. Okay? So, these are the elements that you need to prove, okay, in order for self-defense to be used as a justifying circumstance. Okay? So, there is defense of honor, defense of property, okay, defense of relatives. Okay? These are valid justifying circumstance. Defense of strangers. Take note of the elements class. Okay? As reference, I have given notes in the files. And furthermore, I also uploaded the codal provision of the revised penal code in the files. So, just take note of it and use it as reference as we discussed. Okay? Another justifying circumstance is avoidance of a greater evil. Okay? Take note of the elements. Next, fulfillment of duty or lawful exercise of right or office. Okay? So, this is applicable in your profession. You are police officer. Okay? So, being a police officer, you are duty bound to preserve the peace and order in your jurisdiction. Okay? Another justifying circumstance is the battered woman syndrome. Okay, so it will be discussed. Battered woman syndrome, I will just read the definition. However, I have given a case analysis. Okay, it will be exhaustively discussed in the case analysis, which which I have provided in your files. So I will just read the definition. Battered woman syndrome refers to a scientifically defined pattern of psychological and behavioral symptoms found in women living in battering relationship as a result of cumulative abuse. Okay? So, battered woman syndrome as a defense. Okay? So, if a woman who is being abused by the husband, and due to this series of abuse, okay, the woman killed the husband as a self-defense because probably there is danger to the life of the woman, then battered woman syndrome is a valid defense as a justifying circumstance. Okay? So, these are the elements. Still, there are elements that you need to prove in court. Okay? So, in case analysis, you will appreciate the battered woman syndrome as a defense in prosecution, against the prosecution. You can use it if you are the victim. You can use it as your defense. Next is exempting circumstance. Okay? So, in law, there are 6 types of exempting circumstance. Okay? So, you have committed a crime. However, because of certain factor, you are exempted. So, what are these factors? Example, if you are imbecile or insane, if you are a minor, if there is an accident, if there is compulsion of an irresistible force, okay, you are forced. There is impulse of an uncontrollable fear, okay? And then there is presence of insuperable or lawful cause, okay? So the reason for the exemption lies in the involuntariness or lack of knowledge of the actor or the perpetrator, okay? So earlier we have discussed that free will, intelligence is an element of the crime. So if you are crazy, okay, then it can be used as an exempting circumstance. So in case it is culpable felony, there is absence of freedom of action or intelligence, or absence of negligence, imprudence, lack of foresight, or lack of skill. Okay? So let's define who is an imbecile. So one who, while advanced in age, has a mental development comparable to that of a child between 2 and 7 years of age. Okay? So even though the person look like an adult, but his mental faculty is that of a child, then he is exempted. Okay? Next, who is an insane person? There is a complete deprivation of intelligence in committing the act, but capable of having lucid intervals. So during a lucid interval, the insane acts with the intelligence and thus is not exempt from criminal liability. So like what I have discussed earlier, if the person who is insane acted during lucid interval, then he can be prosecuted. Okay? His insanity cannot be used as a defense, okay, as an exempting circumstance, because when you say lucid interval, the person is acting with full knowledge, with full mental capacity, with intelligence, okay, and so on and so forth. So insanity is a defense in the nature of confession and avoidance, and must be proved beyond reasonable doubt. Okay? So next is minority. Okay? So a child in conflict with the law. So, a child who is alleged as accused of or adjudged as having committed an offense under the Philippine laws. Okay? So, the age of responsibility, I think, was lowered. However, when you say child, the age of majority is 18 and above. So, persons who are age 17 and below are still considered children, okay, in the eyes of the law. Okay, so these are just matters of reading, class. I will leave this up to you. Okay, so another exempting circumstance is accident. The elements or requisites are there. Irresistible force. So next circumstance is the mitigating circumstance. So the following, there are 12 types of mitigating circumstance under the law. First is incomplete justification and exemption. Next, under 18 or over 70 years of age. Okay. Then no intention to commit so grave a wrong, sufficient provocation or threat, immediate vindication of a grave offense, passion or obfuscation, voluntary surrender, voluntary plea of guilt, plea to a lower offense, physical defect, illness, and then analogous circumstance. So when you say mitigating circumstance, okay, so the penalty is lessened due to factors as illustrated in these 12 types, okay? So, these are just matters of reading, class. I will leave this up to you, okay? Because this is just an overview. So, this we have already illustrated the mitigating circumstances. Okay. Next is aggravating circumstances. So when you say aggravating, it increases the penalty. Okay. So those circumstances which raise the penalty for a crime in its maximum period provided by law, applicable to that crime or charge, the nature of the crime. Okay. So the list in this article is exclusive. There are no analogous aggravating circumstances. So what are the aggravating circumstances? Okay? Okay, let's find out. There are 21 aggravating circumstances under Article 14. So the following are the aggravating circumstances which increases the penalty if present. 1. Taking advantage of the public office. Okay. Next, in contempt of or with insult to public authorities. And then with insult or lack of regard due to offended party by reason of rank, age, or sex. Abuse of confidence and obvious ungratefulness. Crime in palace or in the presence of the chief executive, okay? Nighttime, an uninhabited place with a band, okay? Crime committed during nighttime, an uninhabited place or with a band. And then crime committed on occasion of calamity. And then aid of armed men or means to ensure impunity, okay? Recidivism, reiteration or habituality, crime committed due to price, reward, or promise, crime committed when there is inundation, fire, or by use of poison, crime committed with evident premeditation, crime committed using craft, fraud, or disguise, superior strength or crime committed with use of superior strength or means to weaken the defense. Crimes committed with the presence of treachery, ignominy, unlawful entry, breaking wall, floor, or roof, or with aid of persons under 15 by motor vehicle. and then crime committed with cruelty. Okay? So the definitions are there, class. Let's just make a rundown. Okay? Okay. Now, degree. So basically, class. Oh, wait. That ends. Oh, wait. Next circumstance is the alternative circumstances. So, under the alternative circumstances, there are three types of alternative circumstances, which are relationship, intoxication, and degree of education or instruction. Okay? So, when you say alternative, so, for example, the presence of these types can either mitigate or aggravate the penalty. Okay? So, circumstances which must be taken in consideration as aggravating or mitigating according to the nature and effects of the crime. Okay? Next is the absolutory causes. Okay? So, there are four types of absolutory causes, namely instigation, pardon, other absolutory causes, and then acts not covered by law, and in case of excessive punishment. Okay? So, important points. Acts not covered by law and in cases of excessive punishment. Absolutory causes are those where the act committed is a crime, but for reasons of public policy and sentiment, there is no penalty imposed. Okay? So, you are absolved. Now, let's differentiate a very sensitive topic, entrapment and instigation. Okay, very common in your practice class. So, what is entrapment? These are ways and means which are resorted to for the purpose of trapping and capturing the lawbreaker in the execution of his criminal plan. Okay? So, the means originate from the mind of the criminal. A person has planned or is about to commit a crime, and ways and means are resorted to by a public officer to trap and catch the criminal. It is not a bar to the prosecution and conviction of the lawbreaker. Okay, so entrapment is a legitimate operation. It is a lawful operation. Okay, so it can be used during the prosecution of crime. On the other hand, instigation is illegal, not allowed by law. It is frowned upon by law. So what is instigation? The instigator practically induces the would-be accused into the commission of the offense and himself becomes a co-principal. Okay? The law enforcer conceives the commission of the crime and suggests to the accused who carries it into execution. And then a public officer or a private detective induces an innocent person to commit a crime and would arrest him upon or after the commission of the crime by the latter. And then the accused must be acquitted because the offender simply acts as a tool of the law enforcers. Okay? So when you say instigation, you instigate a person to commit a crime. That is why it is illegal. Okay? So here are the examples and definition and requirements for entrapment and instigation. Okay? So pardon, and then extenuating circumstance. So circumstances which mitigate the criminal liability of the offender but not found in Article 13. Okay? So let's go now to persons criminally liable, okay, or degree of participation. Earlier, we have discussed that the actor or the perpetrator can be a principal, an accomplice, or an accessory. So, these are the degree of participation, okay, of persons who are criminally liable. Okay? So, when you say principal, it is the main actor. And by principal, it is further subdivided, okay, by direct participation, by inducement, or by indispensable cooperation, okay? So, when you say direct participation, you are the main actor. You are the perpetrator who commenced and consummated the crime, okay? You materially execute the crime, appear at the scene of the crime, perform acts necessary in the commission of the offense. Okay? So, by inducement. Now, accomplices. So, when is one regarded as an accomplice? Determine if there is a conspiracy. So, if there is a conspiracy, all persons are considered principal because the act of one is the act of all. So if there is as a general rule, the criminal liability of all will be the same because the act of one is the act of all. So what are the other traits of an accomplice? Does not have previous agreement or understanding or is not in conspiracy with the principal by direct participation. Okay? Accomplice can be the tool, okay, or the assistant in the perpetration of the crime. Okay? So here are the requisites. And then accessory, when the felony committed is elect felony. So when the accessory is related to the principal as spouse, okay, just a matter of reading, class. So these are just a matter of reading. Just a matter of reading. Now, let's go to the last chapter of the Criminal Law 1, the penalties. Okay? So, under the penalties, we will discuss the general principles, penalties which may be imposed, specific principal and accessory penalties, measures not considered penalty, application and computation of the penalty, special rules for certain situation, and then execution and service of penalty. Okay? So, there are different juridical conditions of penalty. Okay? It must be productive of suffering without affecting the integrity of the human personality. Okay? Penalty must be commensurate to the offense. Different crimes must be punished with different penalty. Penalty must be personal. No one should be punished for the crime of another. It must be legal. It is the consequence of the judgment according to law. Okay? There must be due process. It must be certain. No one may escape its effects and must be equal for all. Must be correctional. Okay? So, these are the theories involving penalties as a deterrent or prevention, self-defense, reformation, exemplarity, and justice. The reason for penalties. Okay? So, these are just matters of reading, guys. So, let's go to the classification of penalties. There is principal penalties, those expressly imposed by the court in the judgment of a conviction. Accessory penalties, those that are deemed included in the imposition of the principal penalties. And then subsidiary penalties, those imposed in lieu of principal penalties. Example, imprisonment in case of inability to pay the fines. Okay? So, when you say principal penalty, for example, reclusion perpetua. Okay? because you've committed a capital offense, then you are given capital punishment. So what are the accessory penalties of reclusion perpetua? Absolute perpetual disqualification. Okay, so you cannot run for public office anymore. You cannot be appointed anymore. Okay, you are considered civilly dead. Okay, so matters of reading, class. So what are the penalties which may be imposed under the law? So the scale of penalty. The capital punishment is death. Okay? However, in the Philippines, death penalty is suspended. So automatically, it becomes reclusion perpetua. So the following are the afflictive penalty. The highest is reclusion perpetua, and then reclusion temporal, and then perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, and then prisión mayor. Next are the correctional penalties. Under the correctional penalties are prisión correccional, arresto mayor, and suspension. Okay? So, these penalties has different years of service. Okay? And then there is destierro. Okay? Earlier, I've discussed what destierro means. Okay? So, if you are the perpetrator, you are not allowed to go near the victim. Okay? There is a distance. Okay? For example, you are not allowed to go within 200 meters to the victim. Okay? Then light penalties, arresto minor, and then public censor. Okay? Then penalties common to the three preceding classes are the fine and bond to keep the peace. Okay? So when you say life imprisonment imposed for serious offenses penalized by special laws, we have discussed this earlier. And then reclusion perpetua prescribed under the revised penal code. Okay? Just a matter of reading, class. So let's go to the duration. Okay? So penalty if death it is indivisible. Okay? However, in the Philippines, death penalty is suspended. So reclusion perpetua 20 years and 1 day to 40 years imprisonment. Okay? Perpetual absolute disqualification, it is for life. Okay? So if there is accessory penalty of perpetual absolute disqualification, then there is deprivation of public office even if by election. Okay? You cannot anymore run in public office. Okay? There is deprivation of right to vote and be voted for. You are disqualified from public office, and then loss of retirement rights. Okay? So, perpetual special disqualification, it is for life also. Deprivation of office, employment, profession, or calling affected, and then disqualification from similar offices or employment. Okay? So, next is reclusion temporal. The duration of reclusion temporal is 12 years and 1 day to 20 years. Prisión mayor, 6 years and 1 day to 12 years. Okay, we have discussed this. So, specific and principal accessories, matters of reading. Okay. So, prisión correctional, its duration, 6 months and 1 day to 6 years. Suspension, 6 months and 1 day to 6 years. Destierro, 6 months and 1 day to 6 years. Arresto mayor, 1 month and 1 day to 6 years. Okay. So, in destierro, the effect is prohibition to enter within 25 to 250 kilometer radius from the designated place. Okay. Okay, just a matter of reading. Just a matter of reading. So what is civil interdiction? So the effect, there is deprivation of the following rights. So this is an accessory penalty when you are penalized under the law. So loss of parental authority, loss of guardianship over the ward, marital authority, loss of marital authority, and then loss of right to manage property and to dispose of the same by acts inter vivos. Okay? So, civil interdiction is an accessory penalty to the following principal penalties. Death if commuted to life imprisonment, reclusion perpetua, and then reclusion temporal. Okay? Okay. Just a matter of reading, class. So, indeterminate sentence law. Cases will be given for you for case analysis. It will be discussed there. Okay. And then parole. Okay. It will be discussed in the case analysis. The threefold rule. Okay. Okay, these are just matters of reading, class. The notes are already uploaded in the files. Okay, please take note of the principles and then open while you watch this video presentation for reference. Open those notes that I have given. Okay, execution and service. Okay, when you serve your sentence, and then probation law. Okay, what is probation? It is a disposition under which a defendant, after conviction and sentence, is released subject to the condition imposed by the court and to the supervision of a probation officer. Okay, so cases 6 years and below can be the subject of probation. Okay. Just a matter of reading. Suspension of sentence. Okay. So, how this is the last chapter of Criminal Law 1. Okay. Modification and extinction of criminal liability. So, how does a criminal liability extinguish? Okay. So, two kinds of extinguishment of criminal liability. First is total extinguishment. So, by prescription, we have discussed that earlier. The penalty has prescribed. Okay, remember, if it is a capital offense, 20 years. There is 10 years. There is 1 year, depending on the penalty. So, by death of the convict, then it is totally extinguished. By service of the sentence, okay, you serve your imprisonment. By amnesty, by absolute pardon, by the marriage of the offended woman and the offender in the crime of rape and abduction, seduction, and acts of lasciviousness. Okay? Other extinguishment is partial extinguishment by conditional pardon, by commutation of sentence, for good conduct allowance which the culprit may earn while he is serving sentence, by parole, by probation. Okay? So the Supreme Court ruled that re-election to public office is not one of the grounds by which a criminal liability is extinguished. So this is only true in administrative cases but not in criminal cases. So this is like this is the Aguinaldo Doctrine, class, for elective public officials. So when they commit an infraction, they commit an administrative case. So when they are re-elected, so it is deemed that the people, their constituents, has forgiven them. So it extinguishes the administrative liability. Okay? So prescription of crimes, we have discussed this already. Okay? So crimes punishable by death, reclusion perpetua or reclusion temporal, they prescribed in 20 years. Afflictive penalties, 15 years. Correctional penalties, 10 years or 5 years. Okay, depending on the depending of the penalty involved. Okay, so those punishable by arresto mayor, and when the penalty fixed law is compound, it is a compound one. Libel case prescribes in 1 year. Oral defamation and slander by deed, 6 months. Simple slander, 2 months. Grave slander, 6 months. Light offenses, 2 months. Okay. Crimes punishable by fine. So, fine is afflictive, 15 years. If fine is correctional, 10 years. Fine is light, 2 years. Okay. So, prescriptive periods under special laws and municipal ordinance. So, offenses punished only by fine or imprisonment for not more than 1 month or both, 1 year. Imprisonment for more than 1 month but less than 2 years, prescriptive period is 4 years. So, imprisonment for 2 years but less than 6 years, prescriptive period, 8 years. So when you say prescriptive period, this is the time allowed by law where you can prosecute the offense or the felony. So, if the felony has prescribed, then you cannot go after against the perpetrator anymore. Okay? So, imprisonment for 6 years or more, 12 years. Offenses under Internal Revenue Law, 5 years. Violation of municipal ordinances, 2 months. Violation of the regulation or condition of certificate of convenience by Public Service Commission, 2 months. Okay? Okay, we have discussed this already. Pardon, amnesty, just a matter of reading. Okay, so class, that is the coverage of our topic, Criminal Law 1. So once again, I will reiterate that this is just an overview, okay? I'm using this reviewer in order to show the bird's eye view of Criminal Law 1. Later, I will give cases so that you can appreciate the application of the theories which we have discussed. Okay? So, once again, class, I will state that I thank UP Law. Okay? Because I'm using the reviewer of UP Law. Okay? I do not claim any right. Okay? This is not my reviewer. I'm using this mainly for discussion. Okay? Purely for discussion purposes. So, if you have questions, class, just email me or message me, and then we will discuss further the case laws, okay, in another video presentation. So, thank you, class, and God bless us all.